Welcome, I'm Ginny Hallam of Halborns and we're back with our 10 Minutes With sessions. Halborns are part of the brilliant Empowering People group who support with simplifying people challenges and providing practical solutions, which is exactly what these 10 Minutes With sessions are for. You may be aware that there's a new duty coming into force in October requiring all employers to take proactive, reasonable steps to prevent sexual harassment at work and protect employees from it. And today I'm joined by Jess Kelleher, Head of Litigation here at Halborns, to get into the practicalities of what you can be doing to prepare for the new obligation.
Hi Jenny, great to be on the session. Delighted to chat through the new duty on employers and give you some practical tips on preparing for October as we go through what this change means for everyone.
So Jess, I have got a few questions for you. Should we get cracking?
Absolutely.
So not everyone is going to know what the legal definition of sexual harassment is and what the planned legislation is. So can you take us through that first of all? Can you give us a little bit of context as to where we're at the moment and what the future looks like for the new legislation?
Absolutely. So the catchy named Worker Protection Amendment of Equality Act 2010, Act 2023 will make a significant change to the current law on employers' obligations to protect their employees from sexual harassment, i.e. unwanted conduct of a sexual nature which violates their dignity or creates an environment that is intimidating, hostile, degrading, humiliating or offensive to them. Currently, employers are liable for their own acts of harassment and their employees unless they can show they took all reasonable steps to prevent harassment or discrimination. Harassment is judged from the employee's perspective, so they'll be protected provided their reaction is reasonable in all the circumstances. These aspects of the law aren't changing. However, from the 26th of October this year, employers will be required to demonstrate that they are complying with the new duty to proactively prevent sexual harassment in their workplaces by taking reasonable steps to prevent it. Examples of sexual harassment could include, but aren't limited to, unwelcome sexual advances, touching, sexual assault, sexual jokes and displaying pornographic drawings, or sending emails with material of sexual nature. A recent case involved a manager repeatedly texting and emailing a trainee, repeatedly asking her to remove her jumper and encroaching on her physically. So in this modern age of hybrid working, sexual harassment can take place regardless of whether you're working remotely. In that case, via text and email. Although this new duty is a slightly watered down version from the original proposal, which required employers to show they'd taken all reasonable steps, and the new legislation no longer includes employers being liable for harassment from third parties, such as clients and customers, the consequences that arise from breaching the new duty mean it's worth taking proactive steps now so that you're compliant ready for October.
And I imagine that there will be some people wondering why it's so important to comply with this new obligation, this new duty, and what the consequences might be. So what does that look like?
That's a great question, especially because we've already seen tribunal cases published in the past 12 months where significant compensation has been made for sexual harassment claims. So understanding the additional consequences of the new duty is really important. So I guess starting with the financial consequence. Although the new duty is not its own standalone claim, it will increase what tribunal awards look like for sexual harassment cases, because if an employee successfully brings a harassment claim, the tribunal will then consider if an employer breached the duty. If they have, the compensation the employer will achieve will then be increased by up to 25%. To put that into some context, there was recently one of the largest sexual discrimination awards against a city company to date, following an employee being subject to lewd comments, including, "I bet you like to be on top in bed," and being told to take a more submissive role, which saw that employee awarded £1.3 million in compensation for her claims. If that claim had reached the tribunal after October of this year, the tribunal would have increased that compensation by up to 25%, which would have seen the employer paying out a further £325,000 in compensation, which is a pretty hefty increase. The Equality and Human Rights Commission will also have the power to take enforcement action against employers who don't do enough to prevent sexual harassment. This could include conducting their own investigations, entering into binding agreements with the employer to ensure that they're addressing the issue. That's something that has taken place previously with the likes of McDonald's and IKEA, and possibly even regulatory actions against businesses. Now, the idea behind such strict penalties for breaching the new duty is that every employer understands their responsibility to protect their employees from sexual harassment and make it clear to all that sexual harassment in the workplace is unacceptable, no matter how big or small.
Certainly sounds like being non-compliant has some pretty serious consequences. So what steps would you recommend that people take to ensure they're ready for the new duty?
Well, you'll be pleased to hear I do have 4 practical solutions that we recommend all employers are taking to ensure they're compliant by October. The first would be to ensure you have alongside your anti-harassment policies a specific policy on sexual harassment that is shared with all employees, monitored and reviewed regularly to ensure it's up to date. Within that policy, there should be a clear definition of sexual harassment and it be unequivocal that such behaviour is unacceptable. The policy should contain an effective reporting procedure that is easy to understand for employees to use when raising complaints, such as an online reporting tool, and reassure employees that their concerns will be handled confidentially and that they will be protected from retaliation for raising their concerns, to encourage people to come forward when they see behaviour that is unacceptable. Ensuring that employees know they will be protected after raising concerns is particularly important as it's something that a tribunal will look harshly upon when reviewing reasonable steps taken by the employer, as seen in recent case law where the tribunal paid particular attention to the fact that an employee was subject to a string of sexual assaults after coming forward. As part of having a clear reporting procedure, the second recommendation in practice is for employees to ensure they are properly investigating complaints and thoroughly taking action where wrongdoing is identified. This is particularly important as a recent case involving Lidl has shown that having an anti-harassment policy alone is not enough. Lidl were criticised for allowing a culture to become commonplace and not investigating this employee's concerns. In this case, the employee was awarded £50,000, which after October 2024 could have been increased to £72,500 with the new uplift for failing to evidence reasonable steps to protect this employee from sexual harassment. The third recommendation is for employers to assess and conduct targeted sexual harassment risk assessments to identify risk factors and what action can be taken to minimise risks. For example, when people are working from home, employees are able to contact each other electronically, meaning harassment from a colleague could be taking place at home once the employee leaves the office. A step to minimise the risk of this would be ensuring your policy on IT and electronic communication includes appropriate warnings against harassment and encourages staff to report incidents even if these take place on personal devices. The final practical step I recommend for all employers is to provide regular and in-depth sexual harassment training to all employees, not just managers, as that won't allow you to rely on the statutory defence if faced with a claim. Effective training is more than just ticking a box and saying, this is what the law says sexual harassment is, so don't do it. Obviously, ensuring employees understand the legal standard is important, but it's just as important to include situational examples of what workplace harassment looks like in order to bring their learning to life. This should also include less obvious examples, as quite often this is where we see the issues arise. A great example pulled from recent case law on this is where someone was singing the Victoria Wood song Ballad of Barry and Frida and repeating the line "let's do it" whilst making eye contact with the employee, and this was upheld as sexual harassment. Clearly less blatant than perhaps physical touching someone inappropriately, but as this case shows, will meet the threshold for sexual harassment. Training should also advise employees of what to do if they experience it, linking back to your procedures and policy and how their complaints should be handled, so that your managers understand how to address concerns sensitively and confidentially. An important point here as well is also within the training explaining how employees can stay safe when raising concerns if they're going to call it out in the moment. Perhaps if there's been alcohol involved or they're alone with the individual, it could be safer for them to not raise it there and then in case it escalates the situation even further. So we'd recommend providing guidance on how to raise these concerns afterwards. Helpfully, recent case law has given us some further guidance on what the tribunal are looking for when considering if an employer has effective training in this area. In this case, the defence that the employer had taken reasonable steps to prevent harassment failed where the training was not meaningful and had not been repeated. In light of this, it would be a good idea for employers to keep a record of who has received the training so that they can ensure it's refreshed regularly with up-to-date content and then evidence, if they need to, that they have taken those reasonable steps.
Jess, that's been super helpful as far as the training that's required is concerned, and really insightful. So thank you for that. Obviously, there is lots for people to be thinking about, lots for people to do to protect themselves in respect of this new obligation and make sure that the culture of the business is right, and that everyone can comply with the new obligation. What is it that Helborns can help with then? How is it that you might be able to help some of our contacts, some of our clients to comply with the new requirement as of October?
Absolutely. So I know that it can be tricky to know whether your training is compliant until it's tested at an employment tribunal, which most people obviously won't want to do. So with that in mind, our lawyers are able to review your current training without charge if you drop us an email to the address on screen. As part of the review, we advise on areas that should be improved to ensure your training is up to date and will stand up in a defence against a sexual harassment case. As training needs to be rolled out to all employees within the business, e-learning is a great way to do this effectively. As mentioned a second ago, if you've already got something, we'd be delighted to give it a once-over for you. If you don't and want to get something in place, we've built a fantastic 20-minute e-learning course that will help you tick all the necessary boxes in terms of complying with the new obligation and helping to avoid the potential uplift in compensation if you're on the wrong side of a claim. Unfortunately, we do find ourselves advising on these issues regularly, so we're in a unique position to build a session based on our real-world practical experience. We bring it to life with scenarios, interactive elements, keep up to date with relevant case law and legislation, and ensure employees have to complete an assessment at the end to really embed that learning. To be honest, the best way to check it out is with a demo. So if you scan the QR code on screen, you can get one booked in and we'll walk you through so you can get a hands-on feel for it. For me, this is a new change that all employers should get ahead of with the proactive solutions we've just discussed. As with the new government, this is likely to be the start of changes we can expect to see in relation to protecting employees from sexual harassment at work. With Labour's Green Paper, a new deal for working people, committing to sexual harassment law as a key area of reform. So watch this space.
Jess, thank you so much. It's been really interesting. Always something new to talk about as far as employment law is concerned, isn't there? So watch this space for future 10-minute with sessions. But in the meantime, thank you. And please do contact us if you need any support with what you've heard about today.
Thanks, Jenny.